Hi, welcome back to HOA Hell. I'm Michael Kushner, your host. With me today is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning. Great to be with you again, Mike.
I'm glad you're here. As always, we are coming up on, I think this is we've done well over 20 full-length episodes now, and I've done a number of shorts, so we're starting to grow this thing.
Oh, yeah.
So today we're going to handle something that I think is, we see it pretty commonly, and correct me if you think I'm wrong, but that is HOAs who secretly, or maybe not so secretly, tack on attorney's fees to homeowners who have been maybe the subject of discipline, a hearing, let's say, for violating the rules, or they get a demand letter from the attorney, and then suddenly, when they get their statement, then they see their normal general assessment, and then they see a little added on charge. And it could be anywhere from, a few $100s to a couple $1,000s.
Absolutely. It's surprising to me how frequently this comes up within the context of pre-litigation matters involving HOAs. I mean, demand letters, enforcement steps, anywhere from the starting point through even pre-mediation. I mean, it does not even cross the mediation hurdle. And they get these bills, invoices, under all sorts of labels. I mean, it's oftentimes couched as enforcement fee. What does that even mean? What does that constitute? So to the discerning eye, one has to kind of parse through that and see whether the governing documents provide adequate base for that. And I know we'll delve into that. Well,
that's what today is about, because unless your governing documents, CC&Rs, actually, I'm not even going to say governing documents. I'm going to say CC&Rs. I don't think the rules would do it.
No.
Okay? So I'm going to say, unless your CC&Rs specifically say, and it's going to be explicit, it's not going to be vague, okay, that your HOA can charge you their actual attorney's fees for enforcement of the rules, for example, or if you don't pay and they have to have the lawyer send you a collection letter, okay? Unless your governing documents, and when I say that, I mean the CC&Rs, nothing else, specifically say that you are responsible for that, it is illegal for them to charge you. That's what we're going to talk about today. Because in most cases, those CC&Rs that we see don't have that language. And for the most part, therefore, anytime a homeowner is getting charged any attorney's fees without having gone through a formal lawsuit, either in court or in binding arbitration, where a judge has ruled or the arbitrator has ruled and granted attorney's fees, anytime a homeowner is charged for any kind of attorney's fees, it's going to be illegal, because we rarely see it in the CC&Rs. And that's the only time anything prior to a judgment in the HOA's favor and an accompanying order from the court granting a motion for attorney's fees is ever going to be allowed. And every other time it's illegal. And yet we see it every single week. So let's talk about the law, okay? Let's start with 5975, okay? 5975 says that an HOA can recover its attorney's fees, and a homeowner can recover attorney's fees upon prevailing in a lawsuit. That's the attorney's fees section for the Davis-Sterling Act for enforcement actions.
Correct.
Okay? So basically it says if there's a lawsuit for enforcement, whoever wins, homeowner, HOA, gets attorney's fees. Well, how that's done is, let's say you go to court, you go to trial, you go through the rigmarole of an entire lawsuit, you get through trial, jury, let's say, in your favor, okay? After that's over, you got a jury verdict, your lawyers will do a motion for attorney's fees. And in that motion, they'll attach all of the invoices that they sent you, redacted, of course, to get out all the attorney-client privilege stuff. And then the court will rule, okay? And the court will often cut some fees that it might not agree with, because the other side's going to say, well, we don't think we should pay for that, and we don't think we should pay for that. But generally, you'll get the vast majority of your fees. But that order, following a verdict and a motion by the prevailing party, that order is the part I'm talking about, okay? So what 5975 says is, okay, in such a situation, the judge needs to award. Real simple, okay?
Absolutely.
And then there's 5600, which basically says the HOA can't collect an assessment or a fee that's not specifically granted or permitted in the governing documents. And again, in the context of this statute, I'm going to say CC&Rs. It'd be too easy to pass a rule saying we get our fees. I don't think so. Okay? So what that means is, unless it's a enforcement action that they go to court and prevail in, or the governing documents say otherwise, there's no attorney's fees ever that you're going to be responsible for. End of story. It's that simple. It's black letter, black and white. I don't know what other metaphors I could use.
Right.
Do you agree?
I agree. The only exception that comes to mind is by way of an agreement. If you go in mediation and you agree to something otherwise. But statutorily, those are the only two ways to do it.
If you agree, you agree.
Right.
Right, of course.
Right.
Often when we go to mediation, which is pre-litigation, it's just formal settlement talks, no lawsuit's been filed. This is all before that. You're jumping through the required hoop, let's say. And the parties agree on, the HOA is going to do this and this, and they're going to pay X amount of dollars for your attorney's fees. That's perfectly okay. Or vice versa. If, let's say, our homeowner's in the wrong and we go to mediation because it was demanded by the HOA, and our client might agree to pay a portion of the HOA's attorney's fees. That's different. That's by agreement.
Right.
I'm talking about the wholesale theft here, the scam that HOAs, and this is frequent, folks, the HOAs push on people. And here's the thing. People don't know. Know better. So they get a bill, assuming they even look at your bill, they get a bill and they see it tacked on charge of $750. And they go, what's that? It says attorney's fees or enforcement, and they pay it. I'm talking about that. Not legal unless your CC&Rs say otherwise. And it'll be very crystal clear if they do. Okay? So what are the most common scams that we see? One of them is this consultation charge trick.
Yeah.
Okay? Tell me about that one.
Well, that can come in different forms, but one of the most common ones on the HOA side is the board basically in response to oftentimes a legitimate inquiry by the homeowner, right? Expressing grievances, concerns, following up. They turn to their attorney for a legal opinion and recommendations.
Right. So let me give you the scenario and then you continue.
Yeah.
So I'm a homeowner and I'm wondering, I send a letter or an email to the management company or whatever, and I say, hey, I don't know if that's okay. Can you guys do that? And the HOA is like, well, I'm not sure. Let's turn this over. So they forward the email. They turn it over to to the HOA lawyer. And the HOA lawyer maybe spends a half an hour answering the question.
Right.
And then what would happen?
And then that gets passed on to, erroneously, wrongfully passed on to the homeowner.
So the homeowner who made the legitimate inquiry sees it on their bill, a half hour's time for the lawyer. For asking a legitimate question. And the HOA, in the HOA's credit, the HOA passed it on to the attorney. But then, not to their credit, they passed the fee on.
Right.
Okay? See, that's a scam. They can't do that. They can't do that. Okay? That's a cost of doing business.
Right.
They have to eat that cost. If they go to the lawyer, they go to the lawyer. That's the way it is. Okay? So they can't do that. Not working. Another one we see a lot is something that we call a pre-hearing legal bill. Okay? I'll give you an example. I leave my trash cans out too long, or I'm parking illegally. I violate our HOA's parking regulations, and I get a letter from the attorney that says, hey, you're in violation of this section of the CC&Rs and this section of the governing rules, and the board is going to discuss your case at a hearing that's set for this date at this time. Remember, that has to be, if you've seen my other short podcasts on this, you know that has to be 10 days in advance at least. And then let's say it tells you the things that you could be up for. You could be held accountable for this fine or that fine if if the board finds that you are guilty or whatever. And then a couple of days later, you get your it happens to be your assessment due, and you see that you're being charged for that demand letter. In other words, the HOA had the law firm prepare the letter to get you to the hearing, which they're obligated to do. You got to get that in writing 10 days in advance, blah, blah, blah. But then suddenly you're being charged for that. Okay? No. Can't do it. What about this, Sam? Let me paint another scenario for you. Let's do a post-hearing, okay? You get that letter. You show up at the hearing. You present your defense. The HOA, okay. They consider it. And now, post-hearing, the law requires them to send you something in writing within 15 days about the disposition of the hearing. Either, okay, you've convinced us, you're good to go, or no, we're fining you X. And that fine within the fine schedule and all that. But then you get a bill for the lawyer having prepared the pre-hearing letter, maybe even attended the disciplinary hearing or maybe not, and then having to write that second letter announcing the results. And you get billed for all that. Can they do that now that you've been found guilty at the hearing?
No, and even if they can do a certain portion of it, it's only subject to what Civil Code Section 5600 permits. So it's qualified.
So the answer is, unless your governing documents allow pre-litigation attorney's fees, the answer is back to no. No, no, no.
Right.
Again, that's the cost of doing business. They pay the lawyer. It's part of why they collect dues from you, in addition to maintenance and repairs and all the other stuff. It's to cover the cost of the lawyer and the management company and the vendors and all the other things that your HOA does on a day-to-day basis. So no, they can't do that. Again, another scam. Okay? Then we see something like legal fees as part of a line item on a budget. Okay? Sometimes the board slides legal fees, and this isn't against you in particular. Maybe it's against for all the homeowners. Let's say they try to slide it into a specific monthly dues invoice, and all of a sudden there's a line item for $8 for every homeowner to cover maybe a couple $1,000s because they were looking at the lawyer to, I don't know, to clarify a rule, and they wanted to, get the language for that rule or what that would look like.
Well, as part of a special assessment.
Or anything.
Yeah.
Doesn't matter what, anything. So they try to pass it off to everybody. Again, maybe not you in particular, but everybody. Okay, you and all your fellow members. Again, you can't do that. You can't do that. It's not just disciplinary attorney's fees that are a no-no. It's any attorney's fees that are a no-no. You can't do that. Okay? And then, of course, we see sometimes, and we touched on this a little bit, after you resolve something, you actually reach a settlement. Okay? And then on the next invoice, they try to recoup that. And that's to say, at the resolution, whether it was a mediation or just informally at an IDR, for example, you guys never discussed fees. Okay, it didn't come up. Okay, because in IDR, you're not supposed to have an attorney. It's the whole point of it. You don't have one. They aren't supposed to have one. Okay, it's supposed to be just you and a couple board members, right? But no, they try to tack on that. Again, unless it was an agreed upon aspect of the settlement, if it is outside the course and scope of litigation that the HOA prevails in and the court granted an attorney's fees motion, no. Unless it's in your governing documents, in which case, again, it would be clear, crystal clear.
Right.
Okay? Let me impart this to you. I think I've made this clear. Am I wrong? No, I think I made it clear.
I think you have, yeah.
Let's be clear again. We've talked about the two statutes that control. There's only two, 5975, 5600. Okay? 5975, 5600. Those are the two. Unless your governing documents say something along the lines of, if the HOA attorney is brought in to collect money from you because you haven't been paying your dues, or if the HOA attorney has to send a letter because you are being brought up on charges to appear at a hearing for violating one of the rules, or whatever, if that happens, you agree to pay reasonable attorney's fees. Unless your governing documents say that, and most don't, the only time they can ever charge you one dime for a lawyer is if you are in court or at binding arbitration and the arbitrator or the judge has granted a motion and awarded those fees. End of story. I'm gonna use a phrase I hate and I never use. Hard stop. Okay? It's that simple. It's black and white. Okay? Now, we're here today because this happens all the time.
It does. Shockingly. Yeah.
Frequently. And this is one of those bright lines. This is one of those ones where it shouldn't happen all the time because it is a bright line. Okay? They either can do it or they can't. And it's very easy to tell if they can. There's been a trial or they have it in the governing documents. Right. That's it.
Yeah.
And yet we see it all the time. So, obviously, these cautions need to be shared with you guys. And so, what do you do? What do you do when you are facing this situation like so many thousands of homeowners do every day in this state? What do you do? Well, I'll give you a list of things you do. Number one, demand an itemized invoice. If you get one of those, whether it's in your dues invoice that comes every month, or it's in the mail or whatever, push back. Say, okay, well, I want to see the invoice from the lawyer. I want to see how much time this lawyer really. Now, you might know in your head they can't do this illegal, but I want them to give you the evidence anyway before you declare that it's illegal. ask for an itemized invoice. Okay, you have the right to know exactly who did what and how much time was spent and how much the HOA was charged. Okay, even though you might know this is illegal, still ask for that itemized invoice. Okay, should there be a board resolution to this effect?
I believe so.
In executive session, let's say?
Absolutely, yeah. I mean, they can't just arbitrarily sua sponte come up with, hey, you owe this amount.
Can't be the management company
No.
suddenly saying that.
No.
So it had to have been discussed in a meeting, and it wouldn't be appropriate in an open meeting.
Right.
So it would have to be executive session, and
Exactly.
it's discipline or whatever about a home member,
Right.
so that makes sense.
Right.
Okay, so talk to me about that. They would have to, I want to see some sort of minutes or board resolution where they talked about, where the board talked about me specifically.
Right.
You
And-
being me,
and-
right?
and
You
in this
specifically,
case, yeah.
let's charge them.
And in this case, confidentiality wouldn't apply because
It's you.
it pertains to you.
It's
So-
you.
So you want the info, you're entitled to it.
Exactly.
Yeah.
Next thing I would do, number 3, push back in writing after you've gotten or not gotten, even worse, the information you've requested. Show me the resolution or the minutes and show me the invoice that addresses me. I don't need to see anything else a lawyer does, but there's no privilege there if it relates to me. Okay. I have a right to see. You can redact some of the specific things that might have been discussed, but I want to see the lawyer's invoice, right? Third thing is push back in writing. I have reviewed our governing documents, and I don't see where you have the right to charge me one dime for attorney's fees. Please tell me where in our governing documents you are deriving that right, because I haven't seen it. Okay? You might even say, I can't find it in the governing documents, and I happen to know that the 2 statutes, 5975 and 5600, don't allow you to do this unless it's in the governing documents. So I must have missed something. Please point out where in the governing documents it authorizes you to charge me for these attorney's fees, because I don't see it. Make them answer that. Okay? Make them answer that question. Okay? And they better answer that. Now, if they don't, if they refuse to answer, I would pay it. I would pay it under protest. You can write in the memo, I'm protesting this, but pay it. But then you come to us at MBK Chapman. Okay? And that's when we'll get that back. Trust me, we'll get that back for you. Okay? If it's not in your governing documents and it's in any of the scenarios we talked about today, you're getting it back. Okay? But challenge them. I looked at the governing documents, and I'm familiar with 5600 and 5975, the Civil Code, and I didn't see where you could charge me for any of these fees. So can you point that out to me? Show me what I missed. They won't be able to because it's illegal. Next one. You could also sue them, but you could do it the easy way. Where would I go?
Small claims.
Yeah.
Yeah, small claims.
Small claims court. I could go to small claims court, right? And say to the judge.
And that's assuming that the amount is $12,500 or less, which in most cases would be.
Well, it's going to be.
Yeah. It's not a litigation matter.
Right,
So,
right. So it's going to be, and assuming it's worth your time. But yeah, you're gonna go to small claims court. You're gonna say to the judge, basically, it's like, hey, judge, this is illegal. They're charging me this. I dispute their right to do this. Set them straight.
Yeah.
This violates the Davis Sterling Act and violates the governing documents, frankly. Okay? Small claims, perfectly acceptable way to go. Okay? And then another thing I would do, the last thing I would do, is I would light up the rest of the homeowners. Because if it's happening to you, it's very likely happening to other homeowners. And other homeowners might not have heard this podcast. And we could be talking about thousands of dollars and years of this. I would get the email addresses and the names of every single fellow member of my HOA, and you're entitled to that under 5200. And we have an entire podcast on that. All right, as well as an article on my website, mbkchapman.com. Under articles, you'll find one on 5200. I would get a list of every member, all their emails, and I would send a blast out saying, hey, I was charged for attorney's fees for whatever it was. The governing documents don't allow that, and the Civil Code doesn't allow it. I'm sure if it's happened to me, it's happened to all of you. Please share with me your stories of that happening. And if you start to hear back, well, now you've got a powerful weapon, because that board's now going to be looking at a pretty easy removal.
Yeah.
Okay.
Yeah. Just keep it professional.
Always.
Don't accuse them of theft crimes, but so long as
No.
Yeah.
Keep it factual and professional. But if they're violating the governing documents and they're violating California law, you can say that.
Yeah.
Say, I asked them, I gave them a chance to tell me where in the governing documents I must have missed this authority, and they either refused to provide me one, or they provided me one and it didn't say what they said it said. Well, you guys can look this up for yourself. Look at 5975 of the Civil Code. Look at 5600 of the Civil Code. It doesn't authorize them to do this unless it's in the governing documents or there's been an actual trial in court and they won. And that hasn't happened. So I'm sure this has happened to other people if it's happening to me. And I wanted you all to be aware of that. Very powerful. Yeah. And if that doesn't work, what should they do? They come to us.
Come to us.
Come to us at MBK Chapman.
Can I share a brief story?
Please.
We had a dog incident issue, and I'm trying to be very careful not to, give away any confidentiality here. $18,000 was attempted to be billed against them by way of a reimbursement assessment.
So they called it a reimbursement assessment.
They called it a reimbursement assessment. And the governing documents, specifically at CC&Rs, to your point, made a very vague, sloppy reference to this. And they really screwed up from the notice aspect of it to the due process element of it. So they engaged us, the client. We attended this HOA hearing with them, and we came, with everything. With this board. We kept it professional, but we pointed out the numerous ways that their process was flawed. And this attorney on their
flawed,
side,
illegal.
Illegal. But this attorney, he had gone rogue, reaching out to various agencies and just churning up, the legal fees, which is why this was in pre-mediation yet $18,000 plus.
Even if it was valid, fees. I would have argued the amount.
Guess what? The long story short, the association came back. They came to their senses. Zero. They basically cleaned the slate.
Did they have insurance counsel present at any
They
point?
did not, no.
Okay.
They had two partner-level attorneys on their side in attendance.
Oh, who looked at what the associate had done.
And I want to keep it collegial, but we wiped the floor with them, needless to say.
You did?
Yeah.
Okay. Sam wiped the floor with them is what he's trying to say.
18,000 plus came back with a zero.
Right. In other words, we're not just whistling here when we tell you that this happens.
This actually happens, yeah.
Yeah, it happens a lot. And I remember that because I remember you come back after the hearing and telling me.
Yeah.
So just to be clear, because he's a little modest, I will say, when he came and talked to me about this, and this was months and months ago, maybe even a year ago, the other attorney apparently had driven this without realizing that all these fees, regardless of setting aside the fact that the fees that this person incurred were just unreasonable, because that was the rogue part, okay?
Yeah.
The problem was he wasn't entitled to assess even $1, never mind $18,000. None of it, okay? And Sam just systematically knocked down every single thing this attorney tried to say at this hearing. Just one at a time, knocked it down with the law. Black letter, bright line law. And it became very apparent to this law firm and to the partners at this law firm that the attorney had gone way too far, probably an associate.
And he was a bully. Our client.
Of course he was.
Before she engaged us, she felt violated and bullied.
Yes, I remember. But the point is that cooler heads prevailed when you had more experienced attorneys at that firm looking at what their junior associate had done and said, yeah, this is bad. Because had this gone further, they would have been on the hook for every dollar of our fees. I'll tell you that. The bottom line is he knocked it down from 18 to 0, 18,000 to 0. But I don't care if it would have only been 2,500. It's supposed to be 0.
Same principle.
Not allowed to do it. Bottom line, folks. And I've said it multiple times. I hope I've made it clear. If it's not specifically authorized in those governing documents, we're talking about the CC&Rs. Then the only time, and I don't care how they couch it, reimbursement expense, or they come right out honestly and say attorney's fees. I don't care what they call it. If it's for the attorneys, they don't get it. Not one dime until they've gone to court, beaten you, and gotten a court order granting a motion for attorney's fees. That's all it takes. Anything else, they can't have it. It's that simple. But yet we see it all the time. So forewarned is forearmed. If you like this episode, please hit the like button and be sure to subscribe to our channel, HOA Hell, if you haven't already done that. If you'd like to leave a comment or submit a horror story of your own, we're all ears. We'd love to hear from you. Until next time, have a wonderful day.